And welcome to the Chapter 13 video lecture. In Chapter 13, we're going to talk about common law privileges. And the reason why we're going to talk about common law privileges rather than every privilege that might be out there is that privileges are different depending upon what state you're in or whether you're in the federal system. For instance, the federal system has its own series of privileges. Each state has their own set of privileges. And so in their courts, those privileges will be honored, whereas if there is no privilege for a certain thing in that court, it will not be honored. So let me just give you an example. In some states, there's actually an accountant privilege, so that information given on private financial information to an accountant is considered privileged. That means that it cannot be used by the government to or anyone else to use as evidence in a case. Basically, they can refuse to even talk about what was given to the accountant. The accountant can, in fact, has to take the privilege. That means say that they refuse to answer questions about what was disclosed to them in the finances of the client. And of course, the client has the rights to make sure that that privilege is good and that what they said to the accountant or did to the accountant or what kind of information they gave to the accountant is simply not going to be admissible in a court, because it is privileged. We give that privilege away for a good reason. And let's say we want people to be honest with their accountants about their finances, and so we knew that if information to the accountant was not privileged, we would probably have people who are not being honest with their accountant because they know that anything they say to their accountant can be gotten by another party or by the government and used against them. Okay, well, some states actually have that privilege. California does not, but some states do. So let's assume that we go into a court within the state that has that privilege, but not the state court. We go into the federal court that happens to be in the same state. Well, interestingly, the federal system does not have an accountant privilege. And so if you were in federal court and you were hearing a case involving federal law, for instance, unfortunately for the person who told his accountant everything about his finances that he didn't want anyone else to hear, is going to have those things heard, because there is no privilege in the federal court system for federal based causes of action or crimes for the accountant information. So essentially what this means is that if there had been a state court proceeding where the person had let's say been sued regarding their finances, and they wanted to get to the accountant to find out what they told the accountant about the finances. If it was a state court proceeding, the state court would say, I'm sorry, the accountant doesn't have to answer those questions about what information the client gave them because it is privileged. Now you take the same exact situation, but you bring it into federal court on a federal either crime or civil action based on federal law, and now the federal privileges apply, and there is no privilege for the accountant, and then that accountant must testify in federal court. So it's just kind of it's based on the fact that privileges are something that we don't have to do. We don't have to give people privileges, but we give them privileges because if we don't, there'll be certain bad things that will happen in our society generally. So, for instance, the attorney-client privilege is one that most people understand. So I'll just bring that one as an example. We know that we want clients to be able to speak to their attorneys freely and openly, tell them everything about the case, because if the client can't talk to their attorney freely like that, then the attorney can't defend them or can't prosecute their case appropriately because they don't have all the information. So we don't want the client to be in a situation where they have to worry about whatever they tell their attorneys, something that's going to get out to the government or get out to some party who wants to figure out what the client's been saying. And so we make a privilege saying, no, if you said it to your attorney, whatever you said to your attorney is privilege. You'll never find out what that is because you can't get behind that privilege. And so this is very big in the criminal world because we want the criminal defendant to be able to have the full services of their attorney, and they will not get those services at all if they don't have a good attorney who has all the information. So a client who was wondering whether that what they said was going to get out to the world, or the government, or the prosecuting attorney, would hold back what they said to their attorney and not give the attorney all the information. So we don't want that. And so we have to grant a privilege to the client for any communications with the attorney in order to get what we want, which is a proper representation for clients both in civil and criminal cases. If we didn't do that, we would have the very problem that I just identified. And so we have to give that privilege out. Now these privileges, they're giving away perfectly good information, very truthful, good quality information that would otherwise be available to us to use and prove a case. And so they're essentially, on the one hand, taking away good quality evidence from us, and on the other hand, they're giving us something of public benefit on the other. But every state has a different idea about how far they're going to let these privileges go. And some states make them wider than others, and some make them more narrow than others. And the best example of that is the spousal privilege. You probably heard about it. You can't force a spouse to testify against their spouse. A wife against her husband, or husband against the wife. And there are states that have that, and there is in fact a spousal privilege in California, as in many states. But it differs depending upon states. So if you go to the Bible Belt, where marriage is a very, very sacred thing, and they take it very seriously, in that state, a spouse is not allowed to testify against the other spouse, no matter what. And that's even if there's already a divorce. So you've said something to your spouse in privilege because, that's your best friend, that's your partner, that's someone you can talk to in confidence. We want to keep that kind of confidential relationship going. And so we give you a privilege. So if you say something to your spouse in the Bible Belt states, it will never be used against you, at least not likely. Why? Because the privilege is so broad, it covers anything. So even if you get divorced from that person, that privilege is still good. And even if the spouse wants to testify against you, he or she cannot, because the privilege is that good. Now you get another state, and they say, well, you know what? We're not going to keep this privilege if the two people aren't together anymore, because we're not actually keeping them together anymore. So the purpose of the whole damn thing is sort of gone. So why should we keep this privilege? And so what they do is they say, well, the spousal privilege is good so long as they are married, and so long as it fits within the communication that we allow to be put into the privilege. And so it's limited now in these states. So just to give you an idea that it's just sort of a hodgepodge of laws, if you go and take a good look at the spousal privilege alone in the many different states to see how it is different in the different states, you'll be amazed. It's so much having to do with what the community thinks of the institution of marriage, what that means to them in terms of granting a privilege, and so on. So California was the first no-fault divorce state. Well, we have one of the more limited spousal privileges, as you might imagine, because we don't think as much of the relationship as some of the other states do. All right. So what we're going to do is we're going to study common law privileges, because those are the ones that are the big ones, the ones you really need to know, because you'll see them in almost every state, if not every state. And they have certain commonalities among them, so we can talk about them from what was the common law privileges. Common law privileges were created by courts, and they weren't created by statutes. And so it turns out later that they were generally statutized in most states, because the legislature wanted to get their hands in this one, because you give away important evidence in a case, the legislature wants to be the one to decide that, not the courts. So eventually all the common law privileges went to statutes that were enacted by the legislature, but they were all based on the common law privileges that were already identified by the courts, and some have been extended out quite a bit, way past what the common law ever envisioned. So we've got now privileges in California for victim witness assistants who talk to victims of crime. There's actually a privilege for what those victims say to those people, even though those things might say, well, it never happened, I'm just making it up, and that kind of stuff. Well, there can be a privilege for what they said to the victim witness person, that they don't have to have that revealed in court. Kind of interesting because the criminal defendant would probably want that kind of stuff to be put on and vindicate them, but no, there's a privilege. Why? Because we want them to talk freely to their victim witness advocate, because that person is doing a very important task of taking care of the victims and doing what we can for them. All right, so we're going to go into the common law privileges. We're going to go into the politics of the attorney-client privilege. We're going to talk about communications that fall outside the attorney-client privilege and are not protected. And then we're going to get into the crime-fraud exception of the attorney-client privilege, and then we'll get into the spousal privilege. And then we're going to get into what's called the physician-patient privilege. That means that there are certain privileges for patients when they go see a doctor for the same reasons that you go see an attorney. You want help. Well, the patient needs to be able to know that they can say whatever they need to say to the physician for purposes of treatment without worrying about that being used against them in a court later for criminal or civil purposes. There's also a religious communication privilege. That means the so-called priest penitent privilege. That's where you go to your religious leader and talk to him or her about something that you want to be the subject of your discussion on a religious matter. That goes into a privilege no matter what. Certain counselors, therapists, and social workers, and chiropractors, nurses, dentists, doctors, and so on. Other people who might also be involved in therapy to people, same kind of privileges can hold there too. There's also one for military secrets in the federal system only, not in the state. There's also some privileges that are on the horizon that we'll talk about as well. We'll get into those, okay? All right, so let's look at what a privilege is. It's the legal right and or obligation to refuse to testify on certain matters. What this means is if you have a privilege, you have the legal right, or if you're the person holding the privilege, that means like you are the attorney and you have received information from a client, you have the obligation to refuse to testify on certain matters. And by the way, paralegals can sometimes be put in that position because you will be someone who's required by law to protect the attorney-client privilege, and clients will talk to you to get information to the attorney, and that's one and the same as talking to the attorney. So sometimes you will be the holder of the privilege. You'll be required to keep it and to actually claim it. Of course, you'll have somebody there to help you with that because that's something that we don't want you to mess up on. If you're ever subpoenaed on a matter regarding a client, you want to make sure you go to the supervising attorney, tell them what's going on, and make sure that you have someone there to advise you on how to testify and not how to refuse to testify. All right, FRE 501, that's the federal privileges that have been developed by common law. So the federal privileges have been developed by common law. That means the federal courts have created them. But that's not true in many states. Most states have statutes that have been enacted by the legislature that will bring into play all the privileges that are available. So the common law basis for privileges federally will bring in about inconsistency between privileges in different federal courts in some cases. It's possible we could have privileges in one federal court but not in others until eventually someday they put it all together. And diversity civil actions, though, that's where you take a civil action that could be filed in the state court under state law and you bring it to a federal court because you have people who reside in different states. Then those will use the state privileges in the trial even though it's in federal court. And that's because they're applying state law to a state cause of action. And so they'll also apply the state privileges to that same action. All right, let's look at the attorney-client privilege. It's the big one. It's the one that's of great importance to you as paralegals, but also it's the biggest one where you'll see it being used. Federally, confidential information exchanged between an attorney and a client is privileged against involuntary disclosure in a court. California also has the same privilege under 952 of the Evidence Code, and it's several sections thereafter that actually define and limit the privilege. And so basically, if you're telling your attorney something out in the open where everyone can hear you, then that's not a confidential exchange of information. But if you are talking to them on the phone, you're emailing them, you are texting them, you are in their office talking to them, or you send them a letter, that's considered confidential exchange of information. So whatever that is, it doesn't get out. It's privileged. The attorney must keep the privilege. That means they must refuse to testify if anyone ever asks them, or subpoenas them to testify, and they must not ever reveal it under any other circumstances, but certainly not in court under a subpoena. They must take the privilege and then and see what happens, and we'll see whether there are any exceptions, and that's what the next slide is. Here's exceptions to the attorney-client privilege. Just realize that just because you say something to an attorney doesn't mean it will necessarily be privileged. So you do have to understand that it is a limited privilege. So not everything you say to an attorney will be privileged. So let's go through some of the exceptions. So communications that are made in the presence of others who are not a part of the legal team are not privileged because they show that the communications is not confidential. This is what typically happens. You're a criminal defendant, and you bring your friend in with you to hold your hand as you go in to see your attorney who's defending you in that criminal case. And you talk to the attorney while your friend's sitting there listening. Well, if you let someone else who's not involved in the case listen to what you're talking to your attorney about, it's not a confidential communication. And if that's the case, then it is not privileged because it must be confidential. But one thing you should know is that eavesdropping, like as in someone putting a bug in a phone or putting a wire on where they can hear people surreptitiously, that is not going to take away the confidentiality of the communications. So if someone puts a bug in your pocket without you knowing about it that records everything you say, that's not going to do away with the privilege. So let's assume you're in jail. Your attorney comes to see you, goes in the cell, and the cops record everything that's being said. No, that's not. That's an eavesdropping that will not take away the confidentiality of the communication. It will not take away the privilege. Okay, so eavesdropping, listening on the other side of a wall with a stethoscope or something like that, that's not going to do away with confidentiality. And even if something is said in an open room where people are around, but is said in such a way that it's obvious the person's not trying to allow it to be heard by other people, that will be enough, even if it can be overheard. So it's all based on the intent of the person, whether they intended it to be confidential or not. Next is only actual communications is privileged. If an attorney sees the client do something, then what they see is not privileged. So if you watch someone committing a crime, that's not privileged, even if they may be your client. That's not communication. So watch out for the fact that it's only when they come and talk to you or they give you something or they hand you some information of some sort, documents, whatever it is, that becomes privilege. Also, if they hand you the gun that they murdered somebody with, sorry, the gun is not communications. The client coming to you and saying that this is the gun that I killed the person with, that's communications, but not the gun itself. So the gun would have to be actually given over to the authorities, but you couldn't tell them how you got your hands on it or why you had it. You'd say, I got this gun, I think I should give it to you, and that's it. That's all you can say. All right, next is client's identity, as such, is not protected by the attorney-client privilege. So, for instance, we actually have confidentiality between a client and an attorney, which can cover their actual identity, and that's under what's called the fiduciary duty of an attorney to not do anything that is not in the best interest of their client. And so if you were to go into a law firm, let's say a family law firm, because you want to talk about possibly divorcing your spouse, but you don't want the spouse to know about that, obviously, then it would be a violation of fiduciary duty if the client, or if the attorney were to reveal the identity of their client ever, unless it's made public through a filing in court or something, because it's confidential. But that confidentiality of the fact that you're somebody's client is not protected by the privilege. It's not communications, but it can be protected just by the normal fiduciary duty, not to disclose things that would be not in the best interest of your client. So sometimes an attorney is hired to represent the client in secret. In this case, the identity of the client can be protected by the attorney-client privilege, because what's happening is, you're saying to the person, I'm not even going to let you know who I am until you agreed to keep, my identity secret, because that's essentially the communication. So if they're hired in secret, then it's possible that that can be protected by the attorney-client privilege, but it's always protected by the normal confidentiality that's required between an attorney and client just under the fiduciary duty of the attorney. All right, so corporations have an attorney-client privilege, but only between the corporate attorneys and the corporate employees who speak to the attorney at the direction of the corporate superiors in order to secure legal advice. So it's not just anybody in the corporation who can speak to the corporate attorneys, like, say, an employee or just a non-management type who talks to the attorney. There's no privilege for that, but there is for someone who's actually been directed to go to see the attorney, the corporate attorney, for legal advice about what the corporation should be doing. Now, that's privilege. All right, so if the client voluntarily waives a privilege, then the attorney may testify as to the privileged material. That means they actually say, okay, you know what, you can have it. Why don't you just tell them what I said? Then the privilege is given up, so it won't be enforceable for that reason. There's some more exceptions. If the attorney would need to disclose attorney-client communications in order to defend themselves against a charge brought by the client, or to justify their fee if they sued the client, then the attorney may violate the privilege. Very interesting one. Don't forget to pay your attorney, because they will have to justify their fee. To do that, they have to say, well, this is what my client told me, and that's why I had to do all this work. Well, of course, they're going to be giving up all that information that the client gave in confidence because they're allowed to sue for fee, and they have to, we say that, you know, pay your attorney or you're going to lose your privilege, essentially. Because otherwise, the attorney could never sue for a fee because they can't justify it, because they can't tell anybody why they did any work, because they can't talk about what the client said to them. All right, there's also a crime fraud exception. If the client asks for help or advice regarding committing a present or future crime, the attorney is not privileged to refuse to testify, as what the client said. And this actually happened in one of the cases that I was tangentially involved in, but just tangentially. But it was the Alpha Dog case that you probably saw in the movie. The Alpha Dog case, or Alpha Dog movie, was actually a case in Santa Barbara County where a drug dealer who had a brother who was not involved in the drug dealing was kidnapped by another group of drug dealers because the brother had not paid them like he should have, and they kidnapped his brother, and they held him and said they're going to kill him if you know, they didn't get paid. And they subsequently, while still holding this kid, one of them called up their attorney and said, well, I've kidnapped this guy, and what do I get if he you know, gets killed? What do I get if he you know, if I let him go, or this kind of thing. And it was asking for advice on what would happen on several scenarios of things that were going to either happen right then or sometime in the future. Well, that attorney was actually ordered to come in and testify, and I was there actually in the grand jury where he was ordered to come in. And that was used later as evidence against his client in the criminal case and got a conviction. And, you know, I'm not exactly sure the circumstances of how we found out that that information had gotten to the attorney, because the attorney wouldn't have normally given that up. It would have been someone else who knew that the conversation had taken place. And so we you know, put the attorney on the stand and made him testify, and then the court decided that the matter was not privileged because of this crime fraud exception. So a prima facie case of the existence of the crime fraud exception will have to be made to overcome the attorney-client privilege. So what typically happened in this situation is probably someone who was listening to the conversation knew this guy had called up their attorney, knew what he had said and what he'd asked, and then had gotten advice from the attorney. And somehow that got to the police. The police got that to the prosecutor. The prosecutor then subpoenas the attorney to come in and testify. The attorney says, I'm not going to say anything because I got an attorney-client privilege. And then the prosecutor says, well, I've got someone over here that says this conversation took place. So, Judge, why don't you take this attorney back in the back under confidential interrogation and ask him what really happened, and determine for yourself whether the crime fraud exception applies, and if it does, then make him testify out in court, and if not, then you'll say that the privilege is good, and then we don't get the information. That's typically how it happens. So a prima facie case of the existence of the crime fraud exception has to be made. They could either make it through you know, the person who listened to the conversation, or possibly by actually having the attorney do what's called an in-camera testimony about what happened with the client so that the court can determine whether the crime fraud exception applies before the information is given out in open court. And that's one of the big exceptions to the attorney-client privilege. You don't want to ever ask your attorney about a crime that you're about to commit or you're going to commit in the future, because if you do, it's not privileged. All right, let's look at the spousal privilege. The federal rule is a testifying spouse has a privilege to decide to testify or not to testify against their spouse in a court proceeding. That means their spouse. If they are divorced, they're no longer spouses, by the way, and therefore the privilege should not apply. The privilege extends to any statement made in confidence to the spouse by the other spouse during the time of their marriage. Okay. Many jurisdictions have it so either spouse can take the privilege, and some states will prohibit the testifying spouse from ever being even called to the stand, no matter what. So you can see how broad the privilege is in some places as opposed to others. All right, physician-patient privilege. When a patient consults a physician for diagnosis or treatment, generally all communication between them is confidential. Now, let me just show you what that would mean. You come into the doctor's office, you got a big bullet hole in your arm, and you say, well, I got a bullet hole in my arm, would you please help me to fix it up? And the doctor says, okay, sure, fine, we'll fix you up. That's privileged because you're telling them of your condition, obviously in order to get treatment. Well, fine. But if, on the other hand, you say, well, I just got shot, and by the way, it was John Jones over there who shot me, and the guy, I owed him some money, and he thought he should shoot me as a way to get me to pay him. That part of the conversation is not going to come in. It's not going to be privileged. It will come in. And the reason why is because it's not information that the doctor needed for diagnosis or treatment. Why he got a bullet hole is of no importance to diagnosis or treatment, just the fact that he had a bullet hole. That's all he need. It's all that the doctor needed to know. And so that's the limit of the privilege. Anything else that's said is going to come in because it's not privileged. All right, some exceptions. Peripheral statements that are made to the physician, these are statements that are not necessary to diagnosis or treatment, are not privileged, just as I said. So it's limited only to whatever statements are made for the purpose of diagnosis or treatment, and that's it, nothing more. But it can also, be some very embarrassing information, and information that you certainly wouldn't want the government to have, that gets you diagnosis and treatment, and you want it to be privileged. All right, religious communications. It's a very narrow privilege for communications between a clergy person and followers, and it exists in most states. California's Evidence Code Section 1033. A penitent, whether or not a party, has a privilege to refuse to disclose and prevent another from disclosing. That means preventing the clergy person from disclosing. A penitential communication, if he or she claims the privilege. Penitential means that you go to your clergy person and you confess your sins, basically. And so you're talking about some of the things you did that you didn't think were so right or you think were wrongful. That kind of stuff is what is going to be privileged. But as a practical matter, if you're talking to someone for religious advice about your life, probably it's going to be privileged, even if it's something you may not have thought was wrongful. But again, it's still limited only to things that are penitential. But if you're trying to get religious advice towards your life in some fashion, you're probably going to be covered by it in most states. All right, military secrets, real easy. If secrets involve national security, then the secrets are privileged. That's a common law privilege, but the good reason behind it, of course, is if we didn't keep this privilege, we could have people suing the government, making this government tell them all sorts of stuff about the national secrets that we don't want, and it will affect national security. Can't let that happen, so courts will simply say no, you can't have it, no matter what. No matter even if it means you don't have a case, fine, too bad, because national security is much more important than your case will ever be, kind of thing. All right, very simple privilege on that one. The next one is the news privilege. It's very, very limited, but there was a time when there was no such thing as a news privilege, and what happens is these newspaper reporters will get some confidential informant to tell them about some information. They'll run a story on it. And they'll say it came from a confidential source. And of course, the prosecutor might say, really, you say you have somebody who says that they're the ones who committed this murder. Well, come on in, because we're going to subpoena you into a grand jury and we're going to have you testify. The newspaper person might say, well, wait a minute, I took this under confidence. I can't give this information. If I do, I'll never be believed again, and I'll doing a very wrongful thing to this poor person who gave to me in confidence. And the judge would say, well, too bad, because there's no privilege. You're going to have to testify. And some news people, went to jail for a very long period of time until this privilege finally came around. Because the judge would say, you're going to testify. There is no privilege. You must testify. Newspaper person is going to say, no, I'm not going to do it. The judge is going to say, well, I'm going to put you in jail until you decide to testify. And so they'll be in jail until they do. That's sort of the way that they compel you to testify if you don't testify in a court when you're required to. And because there was a lot of press about those kind of things going on, there were some very famous cases that came up that sort of brought this issue out. Then the legislature kind of just decided that they would run in here and do something. But this is the typical privilege. Any bona fide news organization has a limited privilege to keep their sources confidential so long as there is no compelling state interest in knowing the identity of the informant. So if this is what typically would happen. The newspaper organization would say, well, we found this person. He said that he was the one who committed this heinous murder. Prosecutor puts him up on the stand in a grand jury and says, tell me who this person was who said that they were the murderer. The newspaper person says, I'm not going to tell you, because it was kept in confidence. Okay, the court then says, Judge, I want you to please take this guy in the back under confidence, make him testify to you what kind of information he has about this informant, and I want you, Judge, to decide whether there's a compelling state interest in us knowing that information, because we want to prosecute whoever murdered this person. And then the judge takes this person in the back under a confidential interrogation. There's a record of it, but it's kept secret. It's not allowed out unless the court allows it out. And then the court decides whether this privilege is good or not without actually giving out the information until there's a decision made. And if there is a compelling state interest, then that information will be ordered to be released by the news organization, whether they like it or not. And that's when they will put people in jail if they don't give it up. So it's a very limited privilege. But it does protect certain sources when who said all that is not important, but just maybe just the information is important. But if it's who and there's a compelling state interest, then the newspaper privilege will not hold, and they'll have to testify. All right, let's look at some of the California and how it provides for these privileges. All right, let's look at the lawyer-client privilege in California. They first define what a lawyer is and what a client is, because it happens to be that if you happen to believe someone is a lawyer and you talk to them as if they were a lawyer, then that is all you need for the privilege, even if it turns out they're not a lawyer. This could happen because someone is either masquerading as a lawyer or they may be suspended, but your privilege is still good. All right, so here it is, the actual lawyer privilege. Subject to certain exceptions in Section 912, and except as otherwise provided in the article, the client, whether or not a party. So this means even if they were to subpoena you and ask you what you said to an attorney or what your attorney heard from you, but you're not even a party to the action, it's still a privilege. Has the privilege to refuse to disclose and to prevent another from disclosing a confidential communication between client and lawyer if the privilege is claimed by the holder of the privilege, which is the client, a person who is authorized to claim the privilege by the holder of the privilege, which is the attorney, or the person who was the lawyer at the time of the confidential communication, but such person may not claim the privilege if there is no holder of the privilege in existence, or if he otherwise is instructed by the person authorized to permit disclosure. So what this means is, if you were the original attorney who got the confidential communication, there is no privilege in California if your client is dead, which is very interesting. That's not true in other places, but it is in California. Or if your client tells you to go ahead and waive the privilege and talk about what they said, then there is no privilege. Either way. And so very interesting. I had a case where that exact thing happened, and there was a very, very skilled attorney, very skilled trial attorney who made the mistake of not realizing that in California, the privilege is no good. I'll just give you an example. I had a friend who owned a house with a live-in boyfriend of hers. They owned the house together in joint title, and because they were renting out spaces in the houses, sort of like apartments, they had rental deductions. Well, they didn't have enough money or enough income to really use those, but the boyfriend's mother was very rich and could definitely use those kinds of deductions. And so they decided they would give her the deductions because they couldn't use them themselves. And it turns out under tax law, they had to put mom on title in order for her to get the legal right to take those deductions. So they put mom on title just for that purpose. There was no other purpose for it. And so she's sitting on title getting all these deductions. And then boyfriend gets cancer. And it's one of those fast-acting cancers. It was going to kill him, within months. And so the boyfriend actually contacts an attorney and says, I want to get mom off title because I'm going to die, and I don't want her to be on title, and I want the house to go entirely to this friend of mine, this lady. And he never quite got there because before he could get there, he died. But the attorney actually had that communications from the client directly on the phone. Well, we wanted to prove what this person's intent was because that was important to whether mom really did own any interest in the property or was just there because of tax reasons. And the attorney that was prosecuting the case said, well, I'm sorry, we can't use that. The attorney-client privilege applies. And I went to this attorney and I said, you're an idiot because you didn't look at the lawyer-client privilege in California. If the client is dead, the privilege goes with him. And here it is on Section C of 954. You have to look at these privileges because they're very specific. And they're different in every state. And here's a very unusual one that even a very skilled trial attorney did not know. And so be very careful when you look at these privileges as to what's actually privileged and what is not privileged. Because you might find yourself thinking something's privileged and it's not. Or otherwise, you might think something's not privileged and it is. That could be even worse, depending upon the circumstances. All right, so let's look at maybe some other ones here. Here's the crime or fraud exception. There is no privilege under this article if the services of the lawyer were sought or obtained to enable or to aid to commit or plan to commit a crime or a fraud. So you can't use an attorney for that and have a privilege. Let's see if we can get some other ones here. Here's the privilege not to testify against a spouse, except as provided in other parts of the statute. A married person, very important. They have to be married at the time the privilege is taken, or they're not going to be able to take the privilege in California. A married person has a privilege not to testify against his spouse, which should be his or her spouse, in any proceeding. They have to be married, and the person who's the spouse is the holder of the privilege. So, in California, not only do you have to be married, but your spouse could decide on their own that he or she wants to testify against you, and then you're done. There's no privilege. Because the holder of the privilege is the other spouse, not you. So if you get confidential information to your spouse in California, and they want to nail you, they can do it, because there is no privilege. Or if you're both divorced, there is no privilege either. There you go. Also, there's some areas where it's not enforceable, such as when the person when a crime against the person or property of the other spouse or of a child, parent, relative, or cohabitant of either, whether committed before or during a marriage. So, in essence, if there's a crime or criminal proceeding where the crime is against the spouse or a child, parent, relative, or cohabitant of either, whether committed before or after the marriage, then sorry, there isn't any. Also, the crime of bigamy, certainly. You want someone to testify. Are you married to this person? Yes. Go to another lady. Are you married to this person? Yes. Oh, thank you very much. That's how you prove a case of bigamy. And so you have to ask them to testify whether they're married to the person or not. All right. So here's different parts of waiving the privilege. Here's that's more, but you can see here, this is all under the 900 series of evidence code in California. Here's a physician-patient privilege. Let's see. As used in this article, let's see, holder privilege. Here it is right here. Subject to certain exceptions, the patient, whether or not a party, has a privilege to refuse to disclose and to prevent another from disclosing a confidential communication between a patient and physician if the privilege is claimed by the holder of the privilege, a person who is authorized to claim the privilege by the holder of the privilege, which is the doctor, or the person who was a physician at the time of the confidential communication. But such person may not claim the privilege if there is no holder of the privilege. Same thing, exact thing as the attorney. If the patient is dead, there is no privilege. then the physician can testify to what they said. So you can see there's lots of stuff in here, lots of different exceptions. In fact, there's some very interesting ones. Here's a psychotherapist privilege. So your psychotherapist has a privilege not to testify, or you actually own the privilege, but they are required to hold it for you. There's some additional other ones here that are kind of interesting, such as, let's see, the ones I'm looking for. Here's a clergy penitent privilege, sexual assault counselor privilege. If you're a sexual assault victim counselor, they define what that is, and then you have a confidential communication between a sexual assault counselor and the victim, that's privileged. Interesting stuff, because otherwise you can't talk to this counselor. Here's a domestic violence counselor, same thing. Let's see, privilege to refuse to disclose communication claimants. Domestic violence, yeah. There's lots of different, very, very, very specific privileges here that are very strange. Here's official information. That's what we use for confidential informants. If you're the state and you want to keep someone confidential, we use that one, 1040, 1041, which is privilege against official information or the identity of an informer. So the government can actually refuse to testify as to who gave them the information, so long as it's not necessary for the defense of a criminal defendant. All right, so that's pretty much it for privileges. There's lots and lots of stuff to think about, but you can't really get into what privileges you're talking about until you know what jurisdiction you're dealing with, what court you will be in, and what kind of case you have, because otherwise we don't know what law is going to apply, and whether it's the federal common law privileges or whether it's the state statutory privileges. It all depends on what case you're coming together with and where it's being filed in terms of whether it's a state or federal court. All right, so that's pretty much on our privileges. If you have any questions, again, please feel free to give me a call.